NatRoad Back to Basics series on awards and national employment standards. My name is Michelle and I'm pleased to introduce our speaker, Kylie James. Kylie is a Human Resources and Industrial Relations Specialist and Advisor to NatRoad Members. Kylie will explain notice of termination of employment and redundancy pay. Over to you, Kylie.
Thank you, Michelle. And yes, today we're going to talk about notice of termination and redundancy pay. And this is part of the National Employment Standards. So we actually receive lots of questions about these topics quite frequently. So what I've done in this particular presentation is tried to capture some of those questions that people are asking and provide answers around that. But also, I also want to acknowledge where else I've gathered the information for this presentation. And some of those are in the member resources that are based on our website. So you can go to those member resources and have a look at them. They cover lots of different topics about industrial relations and other matters related to your business. You can go there at any time of the day and check out those resources. And secondly, also looking at the Fair Work Ombudsman website as well. There's a wealth of information on there about our industrial relations system. So we've also tapped into some of those resources there. So what we're going to cover today is ending an employment arrangement. We're going to talk about notice periods and also paying out in lieu of notice. And then we'll step into redundancy pay and when redundancy pay is not payable. So first of all, an employment arrangement, what happens when we end it? Well, essentially it can be ended by an employee or the employer, and it's otherwise known as terminating the employment relationship. So when an employment relationship is terminated, generally a notice period needs to be provided. And that depends, the length of time depends on how long the employee has been in that employment. So the employer needs to provide notice, but also generally the employee needs to provide notice as well. So from an employer's perspective, an employer needs to give an employee written notice of their last day of an employment. Now, there are some exceptions that apply, and we will sort of cover that throughout this presentation. However, generally speaking, they must provide written notice. Now, that can be done by delivering it personally to the employee. You can either leave it at the employee's last known address. You can send it by prepaid post to the employee's last known address. And so if you want to do that, you can also register that. So you get a notification that the employee's actually received that notice. Or if the employee agrees, you can send it electronically by email or text message. The notice period starts when you tell the employee that you want to end the employment, and it ends on the last day of employment. So from an employee perspective, employees should check their award, their enterprise agreement if they are covered by one, or their contract of employment that they would have got at the start of their employment, or potentially even a workplace policy to find out how much notice they need to give to resign from their job. Employees who are resigning often don't need to give their notice in writing. Quite often they give it verbally to their employer. Their employer might ask them to follow up, but it's in writing, but it's not necessarily. Verbally is okay. The notice period starts when an employee gives notice that they want to end their employment, and it ends on the last day of employment. So once the employee is given notice, the employer can either let the employee work out the notice period, or they can tell the employee to leave early and pay them in lieu of notice. So if the employer decides that the employee can leave early, the employer is required to pay them the full notice period that would apply if they were terminating or ending the employment arrangement. So what is the minimum notice periods? The National Employment Standard outlines the minimum notice period required when dismissing, terminating, or ending an employment relationship. An employee over the age of 45 years old who has worked for an employer for at least 2 years is entitled to an additional 1 week's notice. So generally speaking, under the National Employment Standards, the minimum notice periods is as follows. So not if an employee has been working for an employer for not more than 1 year, they must receive 1 week minimum notice. If they've been working for them for more than 1 year, but not more than 3 years, it's 2 weeks notice. If they've been working for them for more than 3 years, but not more than 5 years, it's 3 weeks notice. And then if the employee has been working for the employer for more than 5 years, they must provide 4 weeks notice. Some questions we get around probation. Does notice periods still apply during probation? And the answer is yes. Notice periods still apply during probation, and the employer still has to pay out the notice in their employment contract, the award, or the agreement, whichever is applicable to the particular situation. Generally speaking, during probation, it's typically 1 week's notice, generally because probation is less than 1 year. For serious misconduct, so this is where something really serious happened, and it provides the employer the ability to dismiss the employee on grounds immediately. They don't need to provide any notice, or they don't need to pay out in lieu of notice. So basically, the employment arrangement can be ceased immediately. So it happens at the time of the decision to terminate the contract when the employer has communicated to the employee that their employment is being terminated due to serious misconduct. So I've mentioned that you can pay out in lieu of notice. So an employee can pay out in lieu of notice. They can there's a couple of different options here. So they can let the employee stay for the entire period of their notice. So for example, if an employer has to provide 4 weeks notice, or the employee needs to provide 4 weeks notice, then they can work out those 4 weeks, and then their employment relationship ends after that period. You can ask an employee to finish immediately, but if you do need to provide notice, such as the 4 weeks, you can then pay them out for that entire 4 weeks. And then the other situation is you can do a combination of the two. You might say, work for 2 weeks, and then I'll pay you out for 2 weeks. So either way, if the full notice period is 4 weeks, you must either pay them out or they must work for that entire period. So when paying out in lieu of notice, you must pay the employee the full amount of the employee would have been paid if they worked until the end of the notice period. So when you're paying them out, that does not include incentive-based payments and bonuses, loadings, monetary allowances, overtime, penalty rates, and any other separable identified amounts. A really common question we get is, what if the employee doesn't give notice? So they turn up, they say, hey, I'm quitting today, see you later. So what happens in this case? So where the employee fails to provide the required notice, the employer may deduct from the wages due to the employee, unless they are under 18 years of age, an amount up to the maximum of 1 week's wage. So for example, if an employee was required to provide 2 weeks notice, but they didn't give any notice, the employee may only withhold the value of 1 week's wage. So wages does not include an amount due to the employee for accrued but untaken annual leave or long service leave. Any deduction made from an employee's wage on the basis that they have not given the required notice must not be unreasonable in the circumstance. And the ability to deduct an amount from wages will not apply where the employer has agreed to accept less than the required period of notice. So as an example there, if you have agreed to only 2 weeks notice, but the employee really should be giving 4 weeks notice, you can't then go and withhold an extra 2 weeks because you've agreed for 2 weeks notice, is acceptable. So what if an employee gives more notice than needed? So sometimes this does happen. Generally, the employee is giving notice, more notice than they need in good faith. So they can do that under their award, their agreement, or their contract of employment. The employer does not have to accept this notice. In such situations, the employer should inform the employee that only the period prescribed by the relevant instrument is accepted. So as an example, if the employee needs to provide 4 weeks notice, but says, I'll give you 8 weeks notice, the employer only needs to accept 4 weeks notice. So if the employee only works the minimum notice period, the employer doesn't have to pay the extra notice period. Another common question we get is, can an employee take leave during a notice period? The answer is yes. Yes, they can, as long as it's agreed by the employer. So there's two different situations here. So for annual leave, an employee must still apply for the leave as if they would at any other time during their period of employment. And then it is up to the employer to decide whether to approve the leave or not. An employer can't force an employee to take annual leave as part of a notice period. So it really, again, it comes down to whether the employee wants to request for that leave, and then the employer can decide to approve it or not. For personal carers leave or sick leave, if an employee becomes ill or injured during a notice period, they can take personal carers leave if they give notice of the leave as soon as possible and they provide suitable evidence, such as a medical certificate or a statutory declaration. So moving on to redundancy pay. Redundancy can be described as a situation where an employer no longer requires a person to carry out work of a particular kind or to carry out work of a particular kind at the same location, and it is not due to the ordinary or customary turnover of labour. Redundancy refers to a job becoming redundant, not the employee becoming redundant. And when an employer makes an employee's job redundant, they may need to pay them employee severance or redundancy pay. Now, redundancy can happen in a few different situations. It can be because new technology is introduced, such as a machine can now do the job rather than a person doing the job. A business can slow down due to lower sales or production. A business can close down. It can relocate interstate or overseas, or there can be a restructure or a reorganization because of a merger, or even a takeover happens. If it is a genuine redundancy, the employee isn't able to make an unfair dismissal claim. A dismissal is not a genuine redundancy if the employer still needs the employee's job to be done by someone. So for example, if they indicate that it's a redundancy, but then they go and hire someone else to do the job, that's actually not a genuine redundancy. So therefore, the employee may be able to apply for unfair dismissal. A dismissal is also not a genuine redundancy if the employer has not followed the relevant requirements to consult with the employees about the redundancy under an award or a registered agreement. It's also not a genuine redundancy if the employer could have reasonably, in the circumstances, given the employee another job within the business or associated entity. So it could be that there's another location, or there could be a different role that the employee could do. So this is where consultation is actually really important. So under the awards, but also the Fair Work legislation, consulting with employees about major change is a requirement. So employers must consult with employees about major changes they want to make to the business that will impact on the employee's job. So this is explained in the legislation or in the award. If you do want further information on this aspect, please give us a call and we can talk you through what you need to do in your relevant situation. So what are the minimum entitlements around redundancy pay? I will jump to a table very soon because it really does depend on how long the employee has been with the employer as to what the minimum entitlements are. But generally speaking, an employee with less than 1 year's continuous employment is not entitled to redundancy pay. When paying out redundancy pay, it is equal to the employee's base rate of pay for their ordinary weekly hours of work. And their base rate of pay is the employee's ordinary weekly rate of pay for their ordinary hours of work, excluding incentive-based payments and bonuses, loadings, monetary allowances, overtime or penalty rates, and other separable identifiable amounts. The employee is also entitled to the notice of termination or payment in lieu. So we spoke about that just previously. Depending on how long the employee works, they have the notice period that you would either need to pay out to them or allow them to work. And then if it's a redundancy, you then will need to provide them with a redundancy pay. So this table that's on the screen now shows you the minimum entitlements for redundancy pay. So just choosing a few. So if a person has worked for at least 1 year, but less than 2 years, they receive 4 weeks of redundancy pay. Choosing another one, if the employee has worked at least 5 years, but less than 6 years, it's 10 weeks redundancy pay. So it's scaled, up, that the longer an employee has worked for an employer, they actually receive more redundancy pay. So finally, at least 9 years, but less than 10 years, they have 16 weeks. But if an employee has worked for an employer for more than 10 years, they receive 12 weeks pay, but they also receive long service leave entitlements, as well as your notice of termination. So there's quite a lot of entitlements that an employee will receive if it's a redundancy. So when is a redundancy not payable? Redundancy pay is generally not payable under the National Employment Standards in the following circumstances. An employee whose period of continuous service with the employer is less than 12 months, an employee of some small businesses, and remembering a small business is one that employs fewer than 15 employees. An employee is employed for a specific period of time for a specific task or for the duration of a specific season. So they're known as fixed term contracts. And employees whose employment is terminated because of serious misconduct. So again, we talked about that in the notice of termination section. And this is where if you're dismissing someone for serious misconduct, their employment ceases as soon as you communicate to them. You don't need to provide them with a notice period or redundancy pay. Other situations where redundancy pay is also not payable if you're a casual employee. However, a casual employee who has been engaged on a regular or systematic basis may not be excluded. So just double check with us around your casual employee and how long they've been working for you. And the final situation where a redundancy pay may not be payable is if it is a genuine redundancy and the employee isn't able to make an unfair dismissal claim. A dismissal is not a genuine redundancy if the employer still needs the employee's job to be done by somebody. For example, they do hire someone else to do the job, has not followed relevant requirements to consult with the employees about the redundancy under the award or their agreement, and they could have reasonably, in the circumstances, given the employee another job within the employer's business or associated entity. So there are a few more situations where redundancy pay is not payable, and that's an employee other than an apprentice to whom a training arrangement applies and whose employment is for a specific period of time or for any reason is limited to the duration of a training arrangement. Also an apprentice, you don't need to pay redundancy pay to an apprentice, an employee to whom an industry-specific redundancy scheme and a modern award applies. This is generally in relation to construction industry as an example. An employee to whom a redundancy scheme and an enterprise agreement applies if both the scheme is an industry-specific redundancy scheme that is incorporated by reference into the agreement from a modern award that is in operation, and the employee is covered by an industry-specific redundancy scheme in the modern award. So in the cases where a redundancy has occurred, there's also a job search entitlement. And this is where an employee who has been given notice of termination in circumstances of redundancy must be allowed up to 1 day time off with pay during each week of the notice period for the purpose of seeking other employment. The employer may request the employee to produce proof of evidence at an interview, or there is no entitlement to pay for the day. A statutory declaration is taken to be sufficient proof for this purpose. So I haven't included all of the clauses, copies of the clauses in this particular presentation. However, the clause numbers for the relevant awards that we generally look at are included on this slide. So for road transport, long distance operations award is clause 29, which is termination of employment, and clause 30, which is redundancy. For road transport and distribution award, clause 34 for termination of employment, and clause 35 for redundancy. And finally, the Clerk's Private Sector Award. It's clause 41, which is termination of employment, and clause 42 for redundancy. So in summary, notice periods apply when ending an employment relationship, and that the notice period varies depending on how long the employee has worked for the employer. If it's a redundancy situation, redundancy may be applicable depending on the situation. And again, redundancy pay does relate to how long the employee has worked for the employer. Given these situations can be complex, I do recommend that you do seek some further guidance or reach out to us about your specific situation if you are entering into a redundancy type situation or you need some further advice around notice of termination. Thank you for your time today, and I'll hand back to Michelle.
Thank you, Kylie. And if you're a NatRoad member and need further advice, as Kylie recommended, just give us a call, 1-800-272-144, or you can email membership@natroad.com.au. And thank you to Ampol for sponsoring this webinar.